morning. The court all rise, please. And order in court.
Please be seated. Daryl, is this on? Thank you. I appreciate it. Good morning, ladies and gentlemen. Thank you all for being here. Let me begin by saying, ladies and gentlemen, that this is a tragic situation. And I certainly am sympathetic to the defense's case. No one here can justify a 14-year-old child being charged, tried, convicted, and executed in some 80 days. That a witness who discovered the victim's body sat on the coroner's inquest and the grand jury possibly, and that the trial lasted only one day. The lawyer didn't ask any questions on cross-examination, which is stipulated to by the state. They called no witnesses, and they offered little or no defense in this case. And also poignantly filed no appeal. In essence, not much was done for this child when his life laid in the balance. But I want everyone to understand that we're not here today to establish the guilt or innocence of George Stinney in this case. He may very well have committed this crime. It is to determine whether or not he received a fair trial. Ladies and gentlemen, our legislature and courts, in their wisdom and evolving sense of decency, has provided safeguards to make sure this would never happen again. And I want everyone to be confident in the justice system as we see it today. We have come so far as a society, and in South Carolina in particular. So I really hope that at this hearing, we focus on the good that we can do in furtherance of our duty of ensuring that justice is served in this courtroom and all courtrooms throughout the country. At this time, I'm going to go ahead and hear an opening statement briefly, if we could, from defense counsel. This is your motion. And then Solicitor Finney, I'd like to hear from you, sir.
Thank you, Your Honor. Your Honor, I'd like to introduce the defense team, Ray Chandler, who's seated to my left, Matt Burgess, his left, and Miller Shealy, who's seated to his left. Your Honor, as you quite pointedly pointed out to everybody here, this is a situation where we have a juvenile, and he was 14 years old at the time that he was executed by the state of South Carolina. Everybody recognized he was the youngest person to have been executed in the state of South Carolina in the 20th and I guess the 21st century, because we don't execute juveniles anymore, and the law has advanced to that point where we don't even consider that a 14-year-old could be executed in this country. So you have very well pointed out the issues, and I won't belabor you on that. But what I would like to do is to read to you a couple of things that we discovered in the state archives that were written to then Governor Olin Johnson. And Olin Johnson was asked after George Stinney Jr. was convicted of this crime. Apparently, as you know, 1944 was a watershed year for this country. I mean, that was D-Day, the year of D-Day. We were in the midst of World War II. So this case was probably not getting a whole lot of press based on what was going on in Europe, based on what was going on in the Far East with Japan. And the United States had to, and I'm sure that most of the newspaper focus was on that, but we found hundreds of letters, and all the letters were not favorable to George Stinney Jr., but most of them were. And one of the letters was written by H.L. Bailey, he was in the U.S. Army stationed in Europe, and I'm quoting from him, and he said, "I'm a white Southern boy. I've been in the Army long enough to know what the Negro boys are losing their lives for this country, and I surely think they should have the same treatment as the whites are getting," he wrote. Okay? If not, what in the world are we fighting for? And throughout this country's history, Your Honor, we have sent men and women to battle to fight for the freedoms that you just spoke about, to make sure that due process is carried out in a way that when we look back in history, that we can say these things were done the proper way and not an improper way. And I think that you hit the nail on the head with that, and so does Mr. Bailey when he wrote that letter. And then there's another interesting letter from a Sunday school teacher from Sumter at the same time, and she was writing to Governor Johnson herself, and her name was C.S. Prescott of Sumter, and she told the judge that, told the governor this: just as sure as this child is electrocuted, this deed will be looked back upon with the shame and remorse in later years by the citizens of South Carolina, she wrote. And the finger of scorn will be pointed at us by other states. And, Your Honor, we believe that is why this case will not, for lack of a better word, die. That this case continues to garner such public outrage. And this is not to diminish in any way the fact that 2 young girls were brutally murdered on March 23rd or March 24th. We really don't know what day they were murdered, but the bodies were found on March 24th, 1944. It's not to diminish that fact. And we know that there are family out there that are hurting, but what we want is the truth to come out. And I think that says it, Ms. Prescott's letter says it best, that we can look back on this and say, at some point in time, was this due process? Do we have a case here where that the court can give a remedy? And we're asking you today to look at that and to give a remedy not only for George Stinney, Jr., but for Betty June Binnicker and Mary Thames. Thank you, Your Honor.
Thank you, sir. Solicitor?
Please, the court, Your Honor.
Yes, sir.
Good morning. Our system of justice is described as the best ever devised by the mind of men. And while it is not perfect, it seeks to settle controversies among citizens and mete out justice to the injured and to the accused. I have no doubt that this proceeding will accomplish that result. I first, Your Honor, want to commend this group of lawyers working for George Stinney for their dedicated efforts and research in preparing this motion and bringing it to this court for review. I also want to thank this court for accepting what I know will be a challenging and probably unappreciated task. We pray you will be given strength, wisdom, and courage in deciding this matter. I was elected solicitor 3 years ago on the promise that I would bring fairness and equality in the prosecution of the cases in this circuit. Our job in the solicitor's office is not to look for guilt, but to seek the truth. In a case like this, our job also is not to simply question the past, but also to learn from it. The Stinney family and the families of the 2 victims and the Clarendon County community as a whole have suffered untold sorrow over this matter. And while we don't have all the answers to what happened in 1944 at the trial, we can take comfort in the fact that, as you pointed out, in 2014, this result would not have happened. We now have legal procedures for review that keep the criminal and the victims apprised of what was going on and keep them in the forefront of the results. The solicitor's office maintains that the record in this case has been missing for 70 years, not because of a miscarriage of justice, but because of the natural result of the passage of 70 years of time. We contend at the close of the defense supporting the motion for the new trial, this honorable court will not have heard substantial and conclusive facts on which to grant the relief sought. While we, along with others, have questions about the 1944 trial and its outcome, this court should follow the legal analysis to one reasonable and just conclusion: that the evidence here is too speculative and the record too uncertain for the motion to succeed. We thank the court for the opportunity to open our case.
Thank you, sir. Mr. Shealy, I understand you're going to address standing and timeliness, sir?
Yes, Your Honor.
Thank you.
May it please the court, my name is Miller Shealy. I'm here in association with counsel to present the issues today concerning, as Your Honor has mentioned, standing and timeliness and the jurisdictional issues that surround that. We don't minimize the difficulty of the issues before the court, either legal or factual. We initially filed a motion for a new trial under the standard rules. One of the problems with this case, and if I may start off this way, one of the problems with this case is, yes, it's 70 years old. And as Your Honor and Solicitor Stinney and my co-counsel have already pointed out, 70 years ago, most of the statutory and rule requirements that would have governed this case, and for that matter any criminal case, did not exist. The criminal procedure revolution that happened mostly in the 1960s had not happened. Basically what Mr. Stinney had a clear constitution, what George Stinney Jr. had a clear constitutional right to back in the 1940s was an appointment of counsel in the capital case. And that was about it. Nevertheless, even at the time, under state law, and Your Honors mentioned this, there were certain procedural safeguards. There was still a due process clause both in the United States Constitution and in the state constitution. And more importantly, there has existed at English and American common law for centuries certain procedural safeguards which preceded even our due process clause, our modern post-conviction relief statute, and even may outdate the habeas corpus procedures themselves. And that is Corum Nobis. And I want to talk a bit about what that is. I have had experience with it as an assistant AG in the past and as an assistant U.S. attorney when I worked there. You don't hear the words Corum Nobis very much anymore. They're Latin. They basically have to do with something that is before the court, something that is present before the court. This is at least a 500-year-old remedy. In that respect, it predates our entire Constitution by many centuries. It is a 500-year-old common law remedy that was developed by the English courts at common law to come to the rescue of defendants who had no other hope. And it could be used in civil or criminal cases. In civil cases today, it is largely a matter of, it is in the past because we have abolished it. We have new rules of civil procedure, but it has not been abolished in context of the criminal law. And no state court has so held. The Fourth Circuit has not so held, and that's why we're here today. Basically what Corum Nobis allows the court to do, this 500-year-old writ, is it allows the court to address errors in the record before it. What that presupposes is that even though a case is passed, even though it's many years past, and this is so in U.S. versus Morgan in the 1950s and other cases, it gives a court the power, and today this is sitting here, believe it or not, the same General Sessions Court, the same office, though we are all different, and only a few people in this courtroom were here in 1944, and certainly not this physical courtroom, but this court, this General Sessions Court, as it sits today, is the same one that convicted and condemned George Stinney Jr. That's what the law says, even though the judges and all the parties are different. Corum Nobis is a writ that allows a court, because the court as an office still has that record before it, to correct those errors. And those errors can be one of two types. They can be factual errors, and you will hear testimony and other evidence very shortly about those factual errors that go to the heart of this matter, and we believe conclusively will show that George Stinney Jr. was innocent, and that's the error in the judgment 70 years ago. Next, the court will also hear other kinds of errors, legal errors, and while there's some debate about this in the law, to be candid with the court, it is very clear from older cases and from learned treatises that Corum Nobis exists to do justice in cases where there were legal improprieties, where there were judicial improprieties, and the court will hear evidence of those as well today and perhaps tomorrow. I would also like to add, Your Honor, with respect to some of the issues, particularly about standing, as you have mentioned, and timeliness. With respect to the standing issue in particular, this is one reason we have brought this for writ of Corum Nobis. The state post-conviction relief statute, which is clearly, we concede, the main engine and the main vehicle for challenging convictions of persons who are currently incarcerated. Therein lies the problem. In the context of that statute, it speaks over and over of applicants. The Rule 71.1 of procedure that governs that speaks of applicants and the forms they have to fill out. While it doesn't say that someone who's deceased has no rights, or certain survivors under the survivorship statute might not assert their rights, I'm unaware of any case under the post-conviction relief statutes that gives family members survivorship rights, and the reference to applicants in the way it does seems to foreclose in any way George Stinney Jr. using that statute today, although if he were alive and could, it would be no question that I think he'd be entitled to relief on numerous bases. The habeas corpus procedure is both statutory and constitutional, and I address this because this goes to standing, because habeas corpus is the last remedy. It's only available when there's no other remedy available. The habeas corpus is the only other remedy which still exists. Even though our post-conviction relief statute has largely taken its place, the court has never read the habeas statute, either in the habeas provisions in the statute or the Constitution, out of the law. The term habeas corpus in Latin, without being macabre, literally means to bring forth the body. It is an order from a court to a warden, a prison official, or someone who has custody of the defendant to bring that defendant to court and answer why they should remain in custody. That's been so since the Civil War, since ex parte McCardle and ex parte Milligan in those days. The roots of habeas corpus prevent us from bringing a habeas corpus action because George Stinney Jr. is deceased. This is the term for 500 years, is that Corum Nobis is only available when a great injustice is done, factually or legally. It is the only available common law writ to get before the court at all. And the writ has latitude. It is elastic. Its boundaries are not precise, and they were not 500 years ago, and they are not today, because it is here. It is this writ, this is part of the genius of the common law, this is when justice fails, when a person, a defendant, a situation falls through the cracks in the law. When the law does not have the provision available to protect a person. Corum Nobis is an equitable style remedy. It was in civil proceedings. It actually is even in the context of criminal proceedings, which makes it a bit odd. The cases clearly hold it's available in criminal proceedings, but it is equitable in nature. And that's where we really get to the heart of what we think is the standing and the timeliness issue. First, there are, and we've cited in my memorandum, there are some cases where widows and family members have stood before the court, both civilly and criminally, and pursued writs of Corum Nobis years after the conviction or the error took place in civil court, and they were denied their proper rights under the law. Your Honor, today, believe it or not, of all of George Stinney Jr.'s siblings, they're all alive but him. Both of his sisters are in the courtroom today. Charles Stinney will be here by virtue of a video deposition. He's alive but too sick to travel. If these people can't stand in the shoes using a Corum Nobis writ of a deceased 14-year-old, then nobody can. And we submit that this is a right, clearly, that George Stinney would have. The only way to pursue it is through his family members, and they can stand in his shoes. They can do this with Corum Nobis. They can't with PCR. They can't with habeas. The standing and the timeliness issue dovetail. It dovetailed because this is the only way to get before the court, even after this amount of time. One also important point with both of these issues with respect to the standing and the timeliness, because this is a remedy in an equitable style, if you will. The reason we have this problem is not because of George Stinney Jr. and his family, and you're going to hear the bad details of that shortly. It's because of the wrongdoing of the state, and by the state I mean 70 years ago, not anyone in the courtroom today at all. But the state is still here, and it's the dirty hands of the state that basically cause any standing problems and any jurisdictional problems for George Stinney Jr. to be here. The purpose of the writ of Corum Nobis is to do justice where justice can't be done in any other way. And if the party against whom we seek justice is the very party that has denied him standing and that has created the timeliness problem, that party should not be able to avail itself today of those technical claims of standing and timeliness. You will hear testimony that George Stinney Jr.'s family had to leave shortly after this crime because they were threatened. And that's why we asked the court to hold the record open and to hear that testimony. They could not be here. They could not come back. They don't live here to this day. And only through the very diligent efforts of these attorneys, my co-counsel, have these facts been made available to bring to the court and present to the court today. There is a real issue about, George Stinney Jr., as the court has mentioned, The crime occurred in late March, and by June the 16th, he was executed. There is no record. There's probably no record because there was no appeal. There was no cross-examination. That's what we know. This case was handled so poorly. His family was treated so poorly in the circumstances of March to June 1944 that his rights were snuffed out then. And it was only later, when the state changed, the political system changed, and the criminal procedure revolution we have today, that we are able to come before the court and even bring his rights in his case to the court in some way where he can get justice. There are other issues here. We have addressed them in our memorandum, and I think I have spoken to most of those. I would just add that there is another issue here as well. The state of South Carolina continues to maintain that George Stinney Jr. is guilty. It continues to maintain that he deserved the death penalty. The state is an organ. The state is an entity. It still maintains that. His family lives with that. They live with those disabilities. They live with those problems. That is part of their story. And more importantly, or just as importantly, is part of the story of the people of the state of South Carolina. This is something that needs to be expunged. It needs to be addressed. It needs to be removed or dealt with in our state's history. We can't correct what happened 70 years ago. But if there's any way today we can say that George Stinney Jr. was not guilty, that he was treated unjustly, we can at least make some step toward dealing with the fact that only South Carolina has the record of executing someone 14 years old in the 20th century. Maybe we can at least recognize that there was a mistake made through this writ of Corum Nobis and deal with that legally in a formal way, and at least that stain will be removed. That's all I have if there are no other questions.
Okay.
Thank you.
Thank you. We'll go ahead and let the solicitor respond.
Please report, Your Honor.
Yes, sir.
Your Honor, I would join in my colleague's request to keep the record open on this matter. Our office has just been served with the notice of the Corum Nobis, and we have not fully researched all the details that we think might be appropriate for the court to consider. However, we do want to put on the record that we object to having the defense be able to have two bites of the apple. The motion filed by the defense several months ago was a 29B motion. We think that that motion, based on after discovered evidence, is the one that was proceeding to the court until last week when the Corum Nobis issue was brought up. We believe that the defense should be required to elect. Are they going to make this a 29B or a Corum Nobis? We do not believe under the law they are able to do both. In the brief submitted by Mr. Shealy on page 4, a quote from Amjur says that if an issue in the case concerning which relief is sought by the defendant could have been raised by a remedy other than Corum Nobis, the issue cannot be reviewed in a Corum Nobis proceeding. There are legislative histories showing that because of the enactment of statutes such as 29B relief, Corum Nobis may not apply anymore even though it was a common law remedy. We would ask the court to review and look at the information that's been submitted by Mr. Shealy and take into account that the state believes that Corum Nobis, while it may be possible to argue, does not apply in this case because it is based on the fact that there is a record for which the court can review. In this case, the record is not complete and it is certainly not clear. My colleagues like to make mention of the fact that there were no cross-examinations of witnesses. No evidence introduced, and all of the records that we've been able to maintain that opinion from come from newspaper accounts, which we have, by agreement today, said are not reliable enough for the court to make a decision on. So quite frankly, this court has to look at a record which is almost devoid, except for some original documents that have been submitted and stipulated to. We are almost void of what actually went on that afternoon during the trial of Mr. Stinney.
And it was my understanding the state had stipulated that no questions were asked on cross-examination and no witnesses were put up during the 2-hour trial of the case. That's what was forwarded to my office, was a stipulation signed by your office and the defense.
Your Honor, we would stand by that stipulation.
So you do agree that there was no cross-examination and no witnesses put forward on
We
behalf of the
stand by that
defense?
stipulation.
Okay.
Your Honor, and further, there was no evidence to corroborate the innocence of Mr. Stinney from any of the reports that we have accomplished here in coming before the court today. Therefore, we should start with the premise that he was given a trial, he was given a lawyer, and at that trial, a confession made by him was introduced into evidence. The dirt on the hands of the state, I'm not aware of, even the state 70 years ago. I have, based on my research, found that the trial judge, Judge Stoll, was very well respected, served a long time in many capacities. The solicitor, likewise, was well respected. 12 jurors who did not have any connection to the indictment process or to any other process heard the case, and a verdict was returned. We would say, Your Honor, that even though the standing of the Stinney family may be comfortable with you, and you may find that they do have standing to present a 29B motion or a Corum Nobis argument, that the timeliness works against them. The state of South Carolina has been here 70 years standing by the results that took place in that courtroom that day. Only now, in 2014, and technically in 2013, has a motion been filed, long after most of the witnesses who could have been competent to testify about those issues come back to court and said what they saw, what they heard, what they know that happened. The timeliness factor here is critical because the state of South Carolina cannot proceed to a new trial based on the fact that 70 years have been allowed to pass by and that we don't have a complete record to go by. I certainly could stand here now and tell you that I am shocked and dismayed that an electrocution took place. George Stinney did not deserve that, and he should not have been put in that position. But I am now looking through the lenses of a lawyer who's been trained under the procedure of 1960s and 1970s and onward. Back in 1944, we should have known better, but we didn't. The fact of the matter is it happened, and it occurred because of a legal system of justice that was in place, and that we, for all we know, based on the record, that it worked properly. Thank you.
I think, Mr. Finney, that you have touched on some of the issues that I have with this case, with there being a missing record, no witnesses that are living that can tell us what we have. I've looked at it, and I don't see that there would be any evidence that Frank McLeod, the solicitor at the time, did anything other than what he was supposed to do and sworn to do. As a judge, I find it very hard to believe that another judge sitting in this capacity who had a long learned record of sitting on the bench would do anything improper. I think that my focus is more on what the defense attorney did or did not do, possibly due to a lack of experience, and certainly given the political climate and certainly the cultural climate during the time. My big concern, again, as we talked about in looking at this case, is the standing issue. It's what, in fact, I can do. What can I rectify? And even if we did retry Mr. Stinney, what would be the result? Again, none of us have the power to bring that 14-year-old child back. So that's where we go to the heart of these standing issues and timeliness as well. This was filed in 2013. Some of the affidavits that were produced to me were provided in 2010, 2009. And again, unfortunately, we have witnesses. We have lawyers who actually tried the cases who have passed away, witnesses that testified in the case. I'm sure all of us would like to have the Deputy Sheriff, Mr. Newman, on the stand to hear his testimony as to what he says was told to him by George Stinney. Again, we don't have the opportunity to have that based on the timeliness. Again, I certainly understand the tenor of South Carolina in 1944, but we did have the civil rights era, and as things changed and progressed and we evolved as a society, some of the questions I have is if we couldn't do it in 1944, why not later? Why not in the 60s? Why not in the 70s? Why not as we go through time? And that's one of the concerns that I had as far as timeliness of this case. Again, we're all new here. I'm a new judge. You all are new people representing the state and the defense, and we even have a new person. You're representing the family as opposed to George Stinney Jr. I think those are the questions that as legal scholars we need to address and look at as well, in addition to the facts and what was presented. So I appreciate y'all's information, certainly on standing and timeliness. I may leave it open somewhat at the end of this hearing to further brief it, but that's something we can address after I've heard the testimony. But I appreciate your comments at this time about it. And let's go ahead, and if y'all are ready to go and appropriate, we can go ahead and put up a first witness if that's what y'all would like to do. Okay.
And Your Honor, we would call Catherine Stinney to stand.
Place your left hand on the Bible, raise your right hand, state your name, please.
Name is Catherine Stinney Roberts.
You solemnly swear or affirm your testimony to the court is the truth, the whole truth, nothing but the truth, so help you God. Thank you. Catherine, Mr. Booth. Please state your full name and spell your last name for the record.
My name is Catherine Stinney Robinson, R-O-B-I-N-S-O-N.
And Ms. Robinson, I apologize for not giving you your last name. I just called you as Catherine Stinney, but I wanted everybody to know the association you have.
Right.
And what's the association you do have with George Stinney Jr.?
He was my brother.
Okay. And Catherine, and I hate to ask the lady this, but, and you're probably going to fuss at me for doing this, but can you tell us your age?
I'm 79.
79 years old.
Yes.
And so how much younger would you be than George if he was alive today?
It was about 5 years.
5 years. So he would be 84? Is that
I'm
correct?
84.
Yeah, 83, 84?
84.
That time frame? Okay. So what was your date of birth?
7/24/34.
7/24/34. So if I was to tell you that George was born on October 21st, 1929, does that give you an idea of the difference in your ages?
About 4 years.
Okay. All right. So can you, Catherine, can you tell us a little bit about yourself and what you've been doing, as the judge stated earlier, what have you been doing for the last 70 years?
High school, graduated from high school, college. I have a master's degree in human development.
And where did you go to college?
Morris College,
Okay.
New Jersey State, and Montclair State.
Okay. And what is your degrees in?
Human development.
Okay. And what did you do with those degrees?
I taught school for 39.5 years.
And where did you teach school at?
Passaic, New Jersey.
Okay. And so obviously when you graduated, I guess, from school, you moved out of state.
When I graduated from Morris College, I lived in Newark. Then I moved to Passaic, and I went to Fairleigh Dickinson University.
Okay. And do you have any children?
I have one daughter.
Okay. And Catherine, you traveled here today?
Since yesterday, we got here last night.
You were on the road and you came down for this hearing?
Yes,
And we have established that you were George's sister, is that correct?
he's my brother.
Okay. And I guess you've heard all the statements that have been made here today. What would you like to see done today?
I'd like to see them find him innocent.
Now, you understand the judge can't find him innocent. The judge
Right.
may have asked for requesting a new trial.
And
And so is that what you're asking for?
whatever it takes to show that he was innocent.
And let's go back, and so you are convinced that he's innocent.
I'm sure of it.
Okay, let's go back to, and tell the court what you remember and how you remember those events as they happened back in 1944. Do you remember, for example, the day before George was arrested?
It's just like any other normal day. You don't think about anything that will happen.
Before you start there, Captain, let me ask you, how do you remember those events?
It was
Why are they so vivid in your mind?
It's very outstanding. It's something shocking I was expecting.
Okay. Is it every day your brother gets arrested?
No.
Okay. And so tell us about Alkaloo back in that time frame. What kind of community was it?
My father took us to movies. He took us to see shows, the circus, all kinds of things that young people would do.
Okay.
And he was always there for us, and he took us to all these to give us those experiences.
Okay. And, but what kind, how about tell me about Alkaloo itself? Where'd your dad work?
My father worked at a sawmill,
Okay.
and we belonged to a Baptist church. We all attend school there
All
in
right,
Alkaloo.
So you attended school at the church?
No, in Alkaloo schools.
In Alkaloo School?
Yeah.
And then you went to church also, did you go to Green Hill Baptist
Green
Church?
Hill Baptist Church,
Okay, and that's located in Alkaloo?
Alkaloo.
Okay. And so, and you remember all of those things, is that correct?
Very good memories.
Okay. And you remember the day before George was arrested? Can you tell us what you remember about that day?
It was just like any other normal day. You go about doing your daily chores, and the next day, everything just went haywire.
Okay. All right. Now, do you recall what George's chores were?
Well, George did several things, but one was taking care of the cow, taking the cow out to graze.
Right. And what was your cow's name?
Lizzie.
Lizzie. You remember
I think it was
that?
Lizzie.
Huh?
I think it was Lizzie.
Okay, Lizzie. Okay. And so that was one of George's duties?
That was one of his chores.
Okay.
His
I say chores. Okay.
chores.
And so one of his chores was to do that.
to take that.
Did, I know you said your father took you to movies, he did things with you guys.
Yes.
I'm assuming he worked hard.
He worked at the sawmill.
And did your mother work also?
My mother was a cook at the elementary school.
Okay,
She cooked there for a while.
okay. So whenever your parents weren't there, who did the babysitting for your parents whenever y'all were out of school?
Well, my mother was always there.
Okay,
We didn't have a babysitter.
all right. So tell me about the day that George and, tell me about Amy and George's relationship, your sister Amy.
They were tight. Wherever George went, she was right with him, like a shadow. She always went with him. Whatever he did, she just wanted to be with him, you know.
And so what's the difference in George's age and your age and Amy's age?
About 3 years each between George and me and Amy and myself.
Okay. And so, do you recall, I think this would have been a Friday, March 23rd, is the day that the Vinegar and the Thames girl went missing. Do you recall that day?
Well, just like any other day, you know, we saw some girls in the community riding their bicycles, and they asked if we knew where they could find some maypops.
Did they ask you that, or is that something that you?
No, we were just in the yard because it was gated. You know, it had a fence around it. But we saw the girls riding, and they were looking for maypops.
Well, explain to the court, you said George's job was to graze the cow.
Right,
And then Amy was his shadow.
right.
And I guess you were in the yard, and you saw these girls that day?
I saw the girls
But you don't
riding on
remember?
their bicycles,
Okay.
or pushing the bicycle.
Okay. But do you know who the girls were?
No, I had never
Have
seen
you
them
ever-
before.
Have you ever met the Vinegar child?
Never saw the girls before that day.
Was it unusual for white girls to be in that area?
They were just children riding. I didn't think about whether they were white or whatever. Just saw the white girls riding. That's it. Pushing the bicycles.
Okay. Do you know whether or not they stopped and spoke to Amy and George?
They might have, because my sister Amy and George were maybe at the railroad sitting down while the cow was grazing. And see, the cow would graze there for a while, and then they would bring the cow back.
And did, at some point in time, did the girls leave?
I don't remember they left there and went on about their business.
Okay. Tell us about what you remember George and Amy doing after that.
George sent Amy ahead to turn the water on.
All right, tell us about how the water happened and all that. With the
Yeah,
cow.
it's a spigot in the yard with a big tub that you turn the water on, fill it up. So he would always send her ahead, and she would run and turn the water on. By the time he got there with the cow, the water was about half full in the tub.
So we grazed the cow, then we watered the cow, then.
And put the cow in the
Right.
shed
And so put the cow up and
for the night. Right.
Okay. Now, do you recall a period of time that you were gone that day, that you didn't, that George was babysitting Amy? Do you recall that?
No, if they were there, I was in the house.
Okay. So you were in the house, and tell the court where the house was in relation to where the cows grazed.
Oh, that was a distance across the tracks, a few, not too far from the house.
So if you're standing there in that witness chair, would it be, and I'm just using this as an approximation because I know it's been a long time ago.
Right.
Is it fair to say it toward the end of the courtroom? Or is it further?
A little further than that.
Okay. Would it be twice the size to the other side of the court? I mean,
Yeah, because the railroad track ran between there, so that's where they would sit and watch the cow graze, and then bring the cow home.
could you see George and Amy from your house?
If I went looking for them, I would have to go to the front because I was usually in the house doing something.
Okay. So you do recall seeing the girls, but you never saw. Is there any point in time that you didn't, that George left the home that you understand that day?
No.
Okay. Now, do you remember or recall the next day, which would have been the 24th, and I think this would have been the day they found the two girls' bodies? Do you remember that day?
I don't remember that day.
Okay. And can you tell us why you don't remember that day?
Trying to think. See, the girls went up past our house
Right.
to wherever they were going, and George came back. I don't remember nothing about the girls the next day because it was business as usual for us.
Right, but do you remember that the girls were missing and a search party was looking for them?
No,
You don't remember that at
I
all?
don't remember that.
Okay. Do you remember when the next day, when your brother George was taken into custody?
Okay,
Do you remember that day?
yes.
Okay. Tell the court what you remember about that day. First of all, were you home when he was taken into
I
custody?
was not home.
Okay.
My mother's not home, my father's not home, just Amy, George, Charles, and myself.
Okay. And so where were you at whenever George was taken into custody?
I was at the beauty parlor. Charles took me to the beauty parlor.
Okay. So.
That was his job.
Okay. All right. So you weren't there when he was taken into custody. But let me ask you this question. When George came in the day before that, though, did you notice anything unusual about George?
Just George.
Okay. I mean,
Nothing different.
If he would have come in and he had, for example, bloody clothes on, would you have remembered that?
I would remember that.
Okay. Did you recall back in those days how many sets of clothes George would have had?
He would, I guess, a change in clothes. You know,
Okay.
you don't have to watch a set and wear a set.
Okay. So would you have, or somebody in the family, would you think somebody would have noticed that George had bloody clothes on, that would have occurred?
Someone would have noticed.
All right. Tell us how big your house was.
It was 3 rooms, like a 3-room flat.
Okay.
A living room, bedroom, kitchen.
Okay.
We had beds in both 2 rooms.
And so you had 3 rooms, and did
The
the kids sleep in a room together?
The kids slept in the middle room,
Okay.
and my parents slept in the front of the house, the front room.
How many kids were in the house at that time? Do you remember?
4 of us.
4 of you? Johnny, your older brother, was living there, is that correct?
No,
He
he
not
was
living there?
visiting. He was not living with us.
Okay. So it was yourself and Amy
Yes.
and George and Charles?
Right.
Okay. So that would have been the 4 kids, and you guys slept in the middle room of a 3-room house?
Yeah, had 2 beds.
All right, so very tight quarters. Would that be a fair assumption?
Yeah, very so.
Okay. And so when's the first time you understood that George was detained by the police officers?
My brother Charles escorted me to the beauty parlor. When we came back, George was not there.
Okay.
We didn't know
And
where he was.
you don't know where he was?
Didn't know where he
Did
was.
you talk to Amy about it?
She wouldn't have known either, except she knew that some men took him.
Okay. And so you discussed that with Amy, and then when's the first time you understood that he was being accused of killing,
It was
Vance
sometime
Girl and
after
Rebecca
that.
Girl? I'm sorry?
It was sometime after that.
Okay. And do you recall what you guys did, in regards to, did you stay in Alcalá?
No, my father made the decision to take us out of there, to take us to our grandmother's house.
Do you
Living,
know why he made that decision?
didn't discuss that with me.
Okay, he didn't discuss it with you. And I don't want you to say anything that you heard, but you didn't hear anything, obviously, about
No.
why. Okay,
No.
so
We
you
just
don't know
leave.
why he made that decision. Can you tell the court, was it in the middle of the night that you guys left? What
It was
happened?
kind of because we, in order to go to my grandmother's house, you had to leave a certain time to catch the train. So we stayed in there until it was time to go out and catch the train to Sumter and then to Pinewood. We were going to our grandmother's.
Okay. And do you know the distance between Alcalá and Pinewood?
No.
Okay. Do you recall that train trip?
I recall being very nervous, just cold and shaking because I didn't know what was going on. All I knew is George was not with us.
Right. Did you ever see George again?
Never saw him again.
And let me ask you this question. Did your parents go and discuss, prior to George being convicted, did you ever see a lawyer come to the house?
No,
Do you recall your parents ever saying, we gotta go see our lawyer for
No.
George? Did the police come back and say, to y'all, did they ever ask y'all any questions?
no,
Okay. Did at any point in time, did anybody from the state of South Carolina come to you and say, you know,
no one,
Catherine, what do you know about this case?
no one.
Okay. And is today the first time you're telling this story?
First time.
Okay. Tell us why today is the first time you're telling this story.
Because it keeps coming up, and I would like to have it solved.
I understand it keeps coming up, but why didn't you tell this story, as the judges said, in 1950? Has anything changed from 1944 to 1950 in regards to race relations in South Carolina?
I don't think so.
Okay. How about from 1955 or 54 to 1964, when we had the Voting Rights Act? Did anything change?
No.
Okay. When did you get the right to vote?
When I became of age,
Okay, when you became of age.
right.
And when was that?
Guess when I was 18.
When you were 18. Do you know when the Civil Rights or the Voting Rights Act came into existence?
I don't recall this minute. I don't recall.
You don't recall, but you remember you at some point in time you got the right to
You
vote.
had the right to vote.
Now, I guess my question to you would have been, is years have passed, and the judge is interested to know why 2013, why 2014, that we're asking her to go back and relook at this case, when you could have asked us in the 60s, or the 70s, or the 80s, or the 90s, or the 2000s.
Sometimes you don't know which road to take or which step to take in order to rectify this.
All right. And let me ask you this question. Did you have did your mother and father have the resources to hire an attorney for an appeal?
No,
Okay. Did anybody ever come to you and say, we're willing to help your family with an appeal?
no,
Okay. Did you go to see lawyers and they tell you that there was nothing that could be done? Or did your parents do that? Did they ask of anybody?
I've heard of a lawyer that was representing him, but really didn't do anything to help him.
Okay. And that would have been a lawyer trial, is that right?
Right.
Okay. So did your parents have any knowledge or any information about the legal system?
No,
Okay. And you went on and moved on with your life, and you have been, this story has been repeatedly come up over the years.
right.
And one of the things I think that the reason it's come up over the years is every time there's a death penalty case in this country, George Stinney Jr. is brought up as the youngest person executed in the 20th century.
Right.
And so from time to time, have you gotten calls from the press talking about this case?
We've talked to Quite a few people. We've had people who came to our house and videotaped certain statements, but that's about it.
Okay. Did you know the legal process?
No,
Okay. Did you know how to get into, to go and talk to an attorney? Did you know how to handle any of those things?
we just didn't do it.
Okay. And Catherine, let me ask you this question. Are you paying this law firm to do anything for you today?
No, I'm not.
Okay. And we doing this on a pro bono basis?
Yes,
So in essence, until someone was willing to step forward to help your family, you had no way of knowing how to do this?
not the first step.
Catherine, let me check with co-counsel. That may be all the questions I have for you. Catherine, I appreciate, Mr. Finney is going to ask you some questions, and then I'll have the opportunity to ask you some questions after that, okay?
All right.
Thank you.
Please, court.
Yes, sir.
Good morning, Ms. Robinson.
Good morning.
My name is Chip Finney, and I'm the solicitor here in Suffolk County.
How are you?
I'm very glad to meet you.
Very nice to meet you too.
We've never spoken, is that right?
What is your name?
Chip Finney.
Oh, Chip.
We've never spoken, have we?
Never.
I think the lawyer, Mr. McKenzie, asked the question and you answered about why you never did anything. It's just that you just kind of put it aside.
Kind of put it aside.
Try to put it away from what you were doing in your life. Let me ask you a couple of questions about your background, please, ma'am, if you don't mind.
All right.
First of all, you said you were born in 1934.
Thank you.
So in 1954, you would have been 20 years old.
Yes.
Between the time that you left Alcaloo with your family and the time that you turned 20, did you live in Sumter that whole time?
I'm sure I did.
All right. And so you graduated from high school here
High school and Morris College.
and March, so you left high school and went straight on into March College.
Yeah, for 2 years, and I went to Georgia for 2 years, and I came back,
All right.
went back to school.
At the time that you graduated from high school, which would have been around 1952,
52.
was your mom and dad still alive?
Yes,
Okay. And they were living in Sumter?
yes.
All right. And after, when you turned 20 in 1954, were you still at Morris College?
I'll try to think, yes. I think so.
You graduated high school in 52?
52,
And then you went to Morris for 2 years?
yes.
53, 54. So
But they
in
went-
1954, you would have probably been coming out of Morris?
But I didn't, I went to live in Columbus, Georgia.
All right,
For
but
2 years.
before you moved to Columbus, Georgia, were you living in Sumter,
Yes,
going to Morris College,
for 2 years.
with your mother and father, living in their home?
They were living in their home.
All right. Ms. Robinson, did your mother and father ever tell you that George had done something bad and that's why he wasn't at the house?
No,
Did your mother and father tell you that you and your brothers and sisters needed to do something to help the memory of George, to straighten out what had done, that happened to George?
they didn't get, not in so many words.
Can you tell the judge, who passed first, your mom or your dad?
My dad,
Dad passed first. He lived in Sumter at the time,
we lived in Sumter.
and you were gone to Georgia by that time? You had already left Sumter
That's,
when your dad passed?
yeah, for 2 years.
All right. And was your mom still here?
In Sumter.
And did she pass after your dad? How many years?
I don't recall this minute.
All right. Have you and your family members during this time, the 50s, the 60s, the 70s, did you all ever have a discussion about getting a lawyer and doing anything about the George Stinney case?
No, it's life as usual.
All right, life as usual. Now, when you started your family with your daughter, was she born in New Jersey?
She was born in Passaic.
New Jersey.
Yes,
And you were teaching school there?
yes,
All right. And you got your master's degree
Yes,
in New Jersey?
yes.
If you don't mind, let me ask you a few questions about 1944.
Okay.
Do you remember going to school with George and Amy and Charles?
Yes.
Did all of you all attend the same school?
Well, we had an elementary school with a few rooms, and then you moved to the other school.
All right. In 1944, were you in the same class as George or Amy?
No.
Or Charles?
No,
So all of you had different rooms to go to,
Right.
different teachers were instructing you?
right.
All right. You testified that you were not home when George was taken by the authorities?
No,
You were at the beauty shop?
right.
Did you say, I couldn't hear, that your mom and dad were not home either?
They were not home.
So, you were with Charles at the beauty store, mom and dad weren't with you. And so George was home by himself, or maybe with
George
Amy?
and Amy,
Just those two?
just those two.
All right. Do you know what day it was that he was arrested?
No,
You know what day the girls' bodies were found?
no,
As it concerns George and the task of handling the cow, you say George would take the cow out of the shed and take him to graze.
right.
Where was the shed in relation to your house?
In the back,
Right behind the house?
behind the house.
Okay. Did you all have chickens
Chickens,
and other farm animals?
chickens, and vegetables.
All right. And the cow stayed in the shed right behind the house?
Yes, behind the house, a little in the back.
And he would have to be taken across the yard,
Through the yard, out of the gate, and down the street.
okay, and down the street, and you had to cross the railroad tracks to get to the field where he grazed?
It was right alongside there, the
Alright.
field was at.
Now, Ms. Robinson, from 1944 to today, this is the first time you've talked about this case.
Yes,
Have you ever written a statement called an affidavit for anybody where you signed it and said, I swear to tell the truth and this is my statement?
no,
You've never done that before?
never did that.
All right. Is there any reason why, after all this time, and people were asking questions, you said people have been to your house, you've given interviews on the radio before?
Not the radio, but I had people come to the house, and they took photos and videos, and you're hoping and praying that this is what they're going to do with it to help you out, but you don't hear from them anymore.
Did you recollect of your own free will that you saw these two little girls riding a bicycle that day in Alcaloo? Or was that because of conversation that you had with Amy and other people?
No, I saw the girls pushing the bike. They weren't riding. I don't know if there were two bikes or one,
All right.
but they were pushing the bikes. They weren't riding.
Do you remember whether you went to school the day you saw the girls pushing the bike, or was it a non-school day?
I don't recall.
All right. And is it your testimony that in all the time you lived in Alcaloo, that was the only time you saw these two little girls pushing their bike in that area?
That's the only time.
Your house in Alcaloo at the time where you lived with your family, how far was it to the Green Hill Church?
It was in walking distance. At that age, you don't know, can't think about miles or whatever.
Yes, ma'am.
It's in walking distance.
And I understand that by the time you were 5 or 6 or 7, you had left and moved to Sumter. In
Not-
1944, when this occurred, you say your family was asked to leave town. You got on the train shortly after George was taken away from the house.
That evening,
Do you remember how old you were that evening when you left on the train?
maybe 7, 8.
You were born in 34. This happened in 44. Was that to be about 9 or 10 years old?
Maybe 9. I was going into 3rd or 4th grade.
Okay, so about 9 or 10 years old at the time.
Yes.
give us a little bit of understanding how far it was from your house to Green Hill. I know a lot of people walked back then,
Yeah.
especially the kids.
Because we walked,
And you walked to church, right, on Sunday?
yes,
Would it take
maybe 10 minutes,
10 minutes walk?
yes.
Do you know what a half a mile is, or a quarter of a mile? Would you say it was a half a mile to the church, or a quarter of a mile? Can you give me a distance?
I could see it in my mind's eyes, but
Yes, ma'am.
walk up across a railroad track and up the road. Didn't have streets, up the road to the church.
The same road, the same railroad track, you had to cross the
Cross
track?
that track to get to the church. Right.
Did you all have neighbors on your street? Did you have
Yes.
a neighbor to the left and
The
a neighbor to
neighbor
the
to the
right?
left, the neighbor was on the right, across the street.
All right. And these neighbors, did they have children your age?
The lady next door to us had some like teenage girls.
All right. Your testimony is that you were at the house when you saw the girls ride by that day,
Pushing the bikes by.
pushing the bike. And that was the only day you ever saw those girls?
Never saw those girls before or after that.
And you don't know of any reason why they were there that day?
They said they were looking for maypops.
So they talked to you.
They said they were looking for maypops.
Now, ma'am, I need the answer to the question.
Okay.
Did they talk to you that day?
No, those girls didn't talk to me.
So they didn't ask you for maypops?
No, they didn't.
Who did they ask for maypops?
They said they were looking for maypops. I just heard that. They were asking someone in the neighborhood.
They didn't tell you that?
They didn't tell me that.
You didn't talk to them?
I didn't talk to them. I just heard it.
Did you see the girls talk to Amy or George?
No,
You just heard
that's what they were looking for.
somewhere along the line, you heard that the girls talked to somebody
To
that asked
Amy
for
and George.
maypops. That's in your mind.
No. Somewhere along the way, they talked to Amy and George.
Now you know that? They did talk to Amy and George?
Yeah, because Amy and George was sitting on the railroad tracks.
With the cow?
Cow was grazing.
Did you see the girls stop and talk to Amy and George?
No.
I thank you for answering my question.
Okay.
Just a few questions on follow-up. Ms. Robinson, you said that you went to school, and I think there's two kinds of school, right? Two different levels of school, like for elementary and then for,
High school?
right. And so was George in high school?
No.
Or you don't remember?
No.
He was in seventh grade, eighth grade? You recall?
I don't recall. He was in the elementary school there in Apple.
And Mr. Finney asked you about the school. How many people at your school that were going to school look like me?
None.
And so this was the days in 1944 where you heard the word Jim Crow, hadn't you?
Heard it?
Okay. And white people stayed to themselves and black people stayed to themselves. Y'all didn't hang out together, did you?
No.
Okay. And so for white girls to be in the area, and I'm assuming the area you lived in was a black area.
Right.
Okay, was that, it may not have been an unusual event, but you remember that because they were there.
They were there.
Okay. And Mr. Finney has asked you about this time frame about, when, you turned this age and this period of time, but we have come a long way in our race relations in this country. Would you say that's a fair statement?
That's a fair statement.
Okay. Do you, as an African-American woman, feel like that you are, at your age, as far as we have come in this country, do you still feel like that we have come so far that discrimination is not still out there?
It might be out there, but I have good friends like you. They're just people like you. So this lady.
So my question to you is that during these preceding 70 years, you've had people come talk to you about this case?
Yes.
Okay. Did your parents have a lot of money?
No.
Okay. And was anybody able to hire an attorney to come forward and help you guys with this case?
No.
Okay. And this is the first opportunity you've had to tell your story in the courtroom, is that correct?
Correct.
Court's indulged, Your Honor. That's all the questions we have, Your Honor.
Mrs. Robinson, I have a few questions for you, ma'am. Is it your testimony here today that you overheard these two girls asking your brother and sister if there were any Maypops in that area?
Unless my sister told me. Sometimes it comes
So
back
it might
to
have
me.
been that your sister Amy told you that that's what these girls had asked. Is that correct? So you
That's
don't
correct.
know of your own independent recollection whether or not these
They
girls
didn't speak
asked.
to me directly.
They didn't speak to you directly, and that's because you said you were closer to the house. Is that
Right,
correct?
right.
And you said your brother George and Amy were down by the tracks, the railroad tracks, grazing with the cow, correct?
Walking up to graze the cow.
So you couldn't have heard them, and you couldn't have heard from that distance, could you have, from the house to the
No,
tracks?
it was not in the house, in the yard.
Okay, but
in the
could you
yard.
have heard
I
based on the
could have-
distance?
I could hear based on the distance of them passing the house.
So Ms. Robinson, did you actually hear them say that, or did your sister just tell you that?
No, I heard them say as they were going looking for Maypops, because my sister was almost up by the railroad track.
Okay.
Okay.
So ma'am, you've just told me two different things. Is it in fact that you did hear them, or that your sister may have told you? I know, it's a long time back.
I know, but
And the reason why I ask you this, Ms. Robinson, because to my understanding, this is the first time that we have heard, or you have come forward stating that you actually saw these two girls looking for Maypops.
I just saw the girls passing.
But isn't it true that this is the very first time that
Very
you have
first
come
time.
forward?
Right.
And you said you have given interviews such that people have come to your house. Have you ever told anyone this before?
No, just different things they would ask. People would come to take videos. And I thought it was for on our behalf, but they might have been used for school purposes or what, I don't know.
Ma'am, you were not originally on my witness list.
Okay,
I was just told this morning about you being here.
okay.
When did you have an opportunity? Did you speak with your sister to know this was going forward, or did you see it in the press, or how was it that you came to be here?
My brother lives in New York, and he's mentioned he was interviewed. My sister's been interviewed, but no one interviewed me. So I'm here today because of that.
Okay. All right, ma'am. Anything further from anyone?
No, thank you.
All right, ma'am, you may step down. Thank you.
Thank you.
Want to take a break for lunch? Lunch? Okay. All right. Mr. McKenzie, I know we got a bit of a late start, but I think now is a very good time to go ahead and break for lunch. It's nearing 1 o'clock, if that's agreeable to everyone, and we don't have any witness issues. Is that correct, Mr. Finney?
It's agreeable, Your Honor.
Mr. McKenzie? All right. Ladies and gentlemen, we're going to go ahead and take a lunch break and be at recess until 1 p.m., where we're going to continue with the testimony in this case. Sir, 2 o'clock, I apologize. Thank you. That'd be quite quick, wouldn't it? I am known not to take a lunch break, but I, of course, need to make sure you all do. So we will all be back here at 2 o'clock, where we'll go ahead and continue with the testimony. Thank you. What? Thank you.
Make sure your law clerk scans you out and push the door.
Got it. Appreciate it. Yeah, we don't let me have her.